The Florida Supreme Court is taking your rights away. Listen to the end so you understand the full picture. I'm Adam Rossen with the Rossen Law Firm, and in today's video, we're going to talk about the new Florida Supreme Court rule that is gutting the speedy trial rules. So first of all, let me go back in time and talk about what the speedy trial rules are. So the state of Florida has a rule called speedy trial. And what it means is that when you get arrested for a crime, for a misdemeanor, you have 90 days to be brought to trial from the date of arrest. For a felony, it's 175 days after the date of arrest. Now, in most cases, we end up waiving our client's right to speedy trial if we need more time to defend the case, work on the case, investigate, take depositions, file motions. But in a lot of cases, this is something that we can use to push the prosecutor's feet to the fire to make sure that we can use the speedy trial rules to get them to quickly dismiss a case, especially if they're having witness issues, victim issues, things like that. So in a lot of domestic violence cases, we really use the speedy trial rules to our advantage. For example, if you're arrested on July 1st and it's a misdemeanor, well, then you have August, September, October 1st, that's 90 days, and they have to bring you to trial within that period. Okay. Now, what the Florida Supreme Court has done is the clock doesn't start ticking from date of arrest. It starts ticking from the date the charges are filed. So that 90 days or 175 days starts from the date the prosecutors file charges. Well, prosecutors have a long time to file charges. So let's say the prosecutors wait 5 months to file charges, and now July 1st arrest becomes charges being filed on December 1st. Now the prosecutors have an additional 90 days in a misdemeanor or 175 days in a felony to go ahead and comply with the speedy trial rules. So really, it puts people under the pending threat of a criminal case for so much longer. It allows the prosecutors to take their time, drag their feet, and have this big, ominous black cloud over people, our community, for almost as long as they want. So this is a major disadvantage to normal people like you and me. Now, there's a second problem with this new speedy trial law. So previously, the prosecutors had a 10-day recapture window, which means if speedy trial is over, then they have 10 days to figure out their stuff and still take you to trial. It's called a recapture period. Well, that 10 days has been extended to 30 days. So again, the Florida Supreme Court has given the prosecutors extra time. There's a big difference between 10 days to get ready for trial or gather your witnesses and send your private investigator out to tell a witness that you're going to have them put in jail if they don't show up, because that's what the prosecutors do in serious cases. Sometimes they'll even arrest people who don't want to show up, and they'll drag them into court and force them to testify. And now that 10-day period has now become 30, which gives them so much of a bigger advantage against defense attorneys and defendants. And the third major change is that previously, when a judge dismissed a case because of speedy trial grounds, that case was over, done. Not able to be refiled by the prosecutors, not able to be appealed, nothing. The case is done, discharged forever. And now that case is only dismissed without prejudice. And when a case is dismissed without prejudice, that means that the prosecutors are allowed to refile. So virtually there's no penalty to the prosecutors. So for example, they miss their time deadline, they miss speedy trial, we file a motion to dismiss, they get their 30-day recapture period, they still can't figure out their witnesses, their game, their case. The judge dismisses it now without prejudice. The prosecutors can come back 30, 40, 60, 120 days later and just refile the charges. So this completely eviscerates defendants' rights here in the state of Florida and gives the prosecutor's office virtually unlimited power. Now, this law does not take effect until July 1st, so all arrests up until July 1st are going to be under the old speedy trial rules, but this is a big problem. This is going to be something that, we at the Rossen Law Firm are going to be vigorously fighting and defending as well. If you have any questions about this, how the Florida Supreme Court has literally just taken away your rights, give us a call. If you have any cases, we're here to help. You can reach out to us anytime, 754-206-6200.